There tends to be quite a lot of confusion when it comes to music rights and sponsored social media publications, which are posted across our social media platforms like TikTok and Instagram. And it's all derived from one misunderstanding. Brands and creators often see that there's music and audios available to them in the library, and they take this accessibility as if it's approval to use the audio. But the question becomes, just because it's available, does it mean the law permits it to be used for commercial use?
Yeah, well, the short answer to that is that it does not. And the reason for that is that many brands and creators are opening themselves up to liability because of the meaningful distinction that there's between the platform that's making available music on their general music library and what the brand may be licensed to do on the commercial context. And the question that should be asked is by many brands and agencies is that what license do they have and what do they actually have cover to use?
Publishing content without the appropriate license can attract serious penalties. And if we have a look at the Copyright Act, a rights holder can pursue an individual or a company who's using or misusing, I should say, the audio or music, and they can seek injunctions, seek damages, and in more serious cases, they can seek criminal liability. So it's really important to be across it. If we look at Section 115 of the Copyright Act, what that allows is for the court to make orders for damages which are uncapped. And the way the court assesses it is based on, okay, well, what is the extent of the infringement? What benefit did the infringer gain from its conduct? And also it'll take into account, well, do we want to set an example from this scenario?
Yeah, and a good application of the use of that section was found in Universal Music Publishing v. Palmer in 2021, where Mr. Palmer used a rewritten version of Twisted Sisters, We're Not Going to Take It, in an advertising campaign without obtaining a license from Universal. Justice Caxton found that Palmer knew of the Universal's copyright, and that brought into play the Section 115, and then there was $1.5 million of damages, so an important case.
While Palmer isn't a social media case, it does establish the relevant copyright principles within that would be applied to instances where unlicensed music is used in social media. Now, if we look at the United States, there was a case between Sony and the Marriott for unlicensed use of music. What happened is the Marriott had engaged and paid 900 influencers to promote their business. And in doing that, the influencers created content that contained music which was licensed by Sony. So Sony sought $139 million in damages, which is a hefty sum to pay. We know that the matter settled confidentially. So we're not sure what that exact figure is, but we can take a guess that it was pretty hefty. And what this indicates to us is that this is not a redundant aspect of the law. Copyright is something that, holders are taking seriously and will pursue. So it's important that content creators and brands are aware of what they can and cannot use for commercial purposes.
Yeah, and I guess it raises the question of who's actually liable when something goes wrong. In a typical sponsored content arrangement, you have three parties. You have the creator, who publishes the content, the agency that commissioned and approved, and then you'll have the brand that ultimately benefited from that arrangement. The instinct is to point at the creator who pressed publish, but under Section 36 of the Copyright Act, it's important to see who authorised the content, the nature of the relationship between the parties, and who had the power to prevent the infringement, and whether reasonable steps were taken to do so.
And this also applies to brands who may republish original content from an influencer or a creator. This may be where a creator really liked a product and genuinely promoted it without being paid, and they had used some unlicensed music because they weren't doing it for a commercial purpose. And then a brand comes along and says, hey, we'd love to use that, republishes that with the same audio that wasn't licensed. They are subject to penalties under the Copyright Act. And it's not a good enough reason for them to say, oh, well, the original content was posted not for the intention of commercial use. These brands need to make sure that they're using music that's accessible in the commercial library only. And if we take a look under Section 31 of the Copyright Act, which defines what communication is, we can see that for each publication or each time a post is published, for example, if the same video is published 5 times, they can be subject to penalties on 5 separate occasions. It's not that they're only going to face penalties for the single video, but actually a fresh infringement arises for each time post has been clicked.
Yeah, and what tends to be overlooked is the influence agreements and brand content agreements are generally silent on music rights. And that leaves, when an infringement claim comes about, it leaves them pointing at one another. And at a minimum, contracts should really state what audio is permitted, who is responsible for obtaining those licenses, and any indemnity provisions that track actual responsibility.
100%. So effectively, check your contract, make sure any licensing liability is stipulated in there, and that just use the music from the commercial library and not the general one to avoid any kind of penalty from the Copyright Act.